But at the end of the day, you are the one who knows your student best. That means that you know what your student needs. If your student is expressing to you, just as an example, I know we touched on bullying yesterday. If your student's expressing to you that they're feeling bullied at school, and the teachers who deal with them every day say, well, we're not seeing that here. Um, know your students' needs, know your needs. And you can push back on that and say, hey, this is how they're feeling. This is what I'm seeing at home. Parent and guardian participation in the accommodations and even modifications for your student to receive FAPE is critical. The input that you have is valuable. And just because it's not coming necessarily from a school environment does not mean that it's not. So I would say, you always want to go into meetings about your student with an understanding of what the needs are and what your clear goals are out of that meeting. Rule number 4, AKF, always keep fighting. I do not mean by always keep fighting, send 34,000 emails every day to the principal. Please do not do that. What I mean by that is advocating for your student and working with your student to get them the best education that they can have is a marathon. It is not a sprint. You're going to win some, you're going to lose some. That's just the reality. I think I speak for all of the attorneys here today when I say that in our practice, we have some wins, we have some losses. What you have to do is you have to keep that mindset. Okay, we're going to dust ourselves off. We're going to move on. We're going to continue advocating for our student. And let's move right into key terms. So, oh, I'm sorry, I have this order wrong. Students' rights. Here's the situation. Students have the same constitutional rights as anyone else. Sometimes I think there's a misunderstanding. Parents think that because students are in school, they don't have constitutional rights, but that is not correct. However, school settings do create some unique circumstances where it's important that your student know their rights. And I would say arguably even more important that you know your students' rights. And there's some examples that we'll get into today. Those are things like locker versus backpack searches, discipline proceedings, and a big one that I see a lot is sports participation. All right, here's those key terms I was talking about. So first up is disciplinary hearing. When I'm talking about this, I'm talking about a hearing in which a student is up for a long-term suspension, so that is a suspension of longer than 10 days, or an expulsion. At this hearing, this is typically in front of a school board. The student is entitled to present evidence in their defense. So that means that they can present physical evidence. For example, if there's video, audio, text messages come up a lot because the kids are all texting these days. So your student's cell phone will likely somehow be involved in their disciplinary proceeding. But it also means that the student can speak on their own behalf, the parents can speak, character witnesses can come, and of course you can have an attorney or advocate there with you. A functional behavior assessment is something that I think comes up quite a bit with regard to discipline. And that's going to be primarily what I focus on today, because I think we've had quite a bit come up about discrimination and what to do when you feel your students being discriminated against, but we haven't had much about these disciplinary hearings. So I'm going to kind of focus on that. With a functional behavior assessment, what that is it's a process that districts use to understand why a student is having challenging behaviors. And it's really geared more toward educational or therapeutic settings. We see them primarily in schools, but I've also seen them in inpatient care facilities, things like that. The goal of this assessment is not so much to say what is the student doing that's problematic. We already know there's some problematic behavior by the time an FBA gets kicked in. What the goal is it's going to be trying to get to the root of that problem, figuring out what is the trigger, what is the reason behind a challenging behavior. Manifestation determination review. I am only going to touch on this really briefly, guys, because Ruth has a fantastic presentation about MDRs that I think is coming up very shortly after mine today. So I'll just define it for you. It is a meeting of your student's IEP or 504 team in which it gets determined whether a student's behavior was a manifestation of their disability. So if your student is on an IEP or a 504 and they engaged in some behavior where they are facing suspension or expulsion beyond that 10 days, they are entitled to an MDR before a disciplinary hearing. So it is an extra step between the behavior and the disciplinary hearing. Next is a threat assessment. Now, I know we talked at length about threat assessments yesterday, but just in case you missed that presentation, that is an assessment that a district may give to a student who has made threats of violence or who was engaged in some kind of threatening behavior. Now, most districts do utilize the National Threat Assessment Center. That's that CSTAG that we touched on yesterday. It's pretty generalized assessment. That's what most districts are using these days. Voluntary withdrawal. This is an agreement between a district and a parent wherein a student is permitted to withdraw from the district contingent on their agreement not to return. And they can do that rather than attend a disciplinary hearing and face expulsion. Now, this is something that we'll get into down the line today, but I do want to draw your attention to it as a potential option in disciplinary proceedings. It is up to the district whether or not to offer that. So just know, but it's something to keep on your radar. All right, I'm going to touch quickly on free speech. I know we had a really great presentation yesterday from Kathy about this, so we're not going to stick to it long. But the most important thing I want you to know is that your student doesn't abandon their constitutional rights at the schoolhouse door. And this includes free speech. This includes, their Fourth Amendment rights and their right to due process. The First Amendment protects your students' right to free speech. But as Kathy discussed yesterday, there's a really fine line between what constitutes their freedom of expression versus things like, for example, a credible threat. So here's an example, okay? Your kiddo cannot be compelled to recite the Pledge of Allegiance. They cannot be compelled to speak. That is within their First Amendment right. When I was in school, and I feel like I'm aging myself here because I don't think most districts do this anymore, but when I was in school, you had to stand up every morning and say the Pledge of Allegiance. They can't force you to do that. If your student chose to sit that out, that's their First Amendment right. However, as we discussed yesterday, and I think Jacqueline and I also mentioned this in our presentation on IEPs versus 504s, your student cannot casually make a joke, let's say about bringing a gun to school, even if it's clearly a joke and it's made in poor taste. This is a threat that's actionable from the district's end. It is not protected under the First Amendment. And so that's something to consider. And it is a conversation that I really do encourage parents and guardians to have with their students, especially as kiddos get older, they progress into junior high, high school. All the kids these days have cell phones. They're all on social media. Things are always being recorded. Things are always being preserved on the internet. And it's something that I think is very important to discuss, and not just once, but to continually have a dialogue with your student about, so that you don't end up in a position where you're having to advocate for them at an expulsion hearing. All right, let's get into the nitty-gritty in terms of student discipline and how you can advocate for your student if they are facing discipline. I'm going to touch on Michigan, Ohio, and Pennsylvania. I know we may have some folks from other states here. If there are state-specific questions, I'll see if I can find anything out for you, but I'm just going with these three because that's what I know. So we'll start with Michigan, where I practice. Michigan has some pretty structured approaches to student discipline. They try to emphasize fairness and student support. So there are a couple of rules in place. Short-term suspensions are limited to 10 days per incident. Once you're beyond that 10-day threshold, that's when your student is entitled to a disciplinary hearing. Expulsions can last up to 180 school days for certain offenses. At that point, once you hit that 180 days, then you can try and petition the school board for reinstatement. State law does require that schools in Michigan follow due process. Now, this includes, importantly, that they send written notice to the student and their parents or guardians about the discipline and about the opportunity for that disciplinary hearing. There's also mandatory consideration of 7 legal factors. In Michigan, there is what's called the restorative justice law, and that sets out 7 factors that schools must consider before they suspend or expel a student. So those 7 legal factors are really critical. The best piece of advice I could give you is if you are going into a disciplinary hearing for your student in Michigan, you want to touch on each of those 7 factors. And it's very simple. I mean, even if you Google 7 factors expulsion Michigan, it'll be the first thing that comes up. We also have a handy handout from the state of Michigan that we can send out, and I'm happy to do that. But it's something that I would really encourage you, especially if you are in a situation where you don't have an advocate or you don't have counsel. That is the most important thing, is to touch on those 7 factors and make arguments in favor of your student. For students with disabilities, as we touched on, an MDR is required if the discipline would exceed 10 days. Shifting to Ohio. Oh, I'm sorry, guys. I'm seeing the polls pop up. Is that popping up for everyone or just me, Mark?
Yeah, it's everyone, and let's just give everyone a chance to answer it.
Sounds good. All right. So the question, guys, is do parents have the right to participate in their students' disciplinary proceeding? And I'm going to just give you the answer in case it is not obvious for what I said. It's yes. You do. You do have that right. And I would strongly encourage you to do so if your student is in a disciplinary proceeding.
And so far, 100% of the people have gotten that question correct, Megan. So
excellent. Okay.
you're
I was
keeping
like,
them
I don't know if I
engaged.
said it in those exact words. All right, it disappeared on my end, so I'm going to keep going, guys. Student discipline in Ohio. Now, in Ohio, it's very similar to Michigan. They're governed by their state law as well as local school board policies. But across the board, those suspensions are capped at 10 days and expulsions extend up to 80 days or more. So the difference is that the expulsion in Ohio is that 80 days or more. But in Ohio, as well as in Michigan, those students are still entitled to basic due process protections. That includes, importantly, that written notice. Now, the reason why I'm harping on the written notice, guys, is that it needs to give you notice of what your student is being disciplined for. So it's not enough to just say, hey, your student is being disciplined, they're up for expulsion. This notice at least needs to give you the bare bones of what happened or what the allegation is so that your student can prepare a defense. They'll have the opportunity for a hearing in Ohio, and they also must be notified of the right to appeal if the hearing does not go their way. For students with disabilities, Ohio does follow the federal IDEA and Section 504 laws, and that includes that MDR requirement. So again, even if your student's in Ohio, I know I practice in Michigan, but that MDR, you have the right to that if the discipline is going to exceed 10 days across the board. All right, Pennsylvania. In Pennsylvania, student discipline procedures are governed by, I believe it is Chapter 12 of the Pennsylvania School Code. And Kathy or Lorraine, please feel free to jump in if I am stating that incorrectly, because those are our 2 Pennsylvania All-Stars, and I want to make sure I'm getting that correct. But essentially, the school code outlines both the substantive rules for these disciplinary procedures as well as your students' procedural protections. So that includes things like their written notice, their right to the hearing, their right to appeal. A principal can suspend a student for up to 10 days in Pennsylvania, but anything exceeding 10 days requires that formal hearing and that approval by the local school board. So students will receive the written notice, same as Michigan and Ohio. They'll have the opportunity for an informal hearing for suspensions. Now, the difference is the informal hearing, typically, you're not bringing legal representation. It's not conducted as almost as a trial, right, with testimony. Whereas with a formal hearing, you're going to be presenting evidence, bringing witnesses, and they'll have that right to a formal hearing in expulsion cases in Pennsylvania. But again, if you look at this last bullet point here, you'll see, of course, that, oh, excuse me, guys, that MDR is still in place if the suspension or expulsion is longer than 10 days. Your MDR rights exist across the board. I know Ruth is going to touch on that more, so I will move on. This chart is just a state-to-state comparison. I'm not going to go through every bullet point with you, but it is something that is included in our PowerPoint. It's in our handouts. I think it's a pretty handy-dandy chart, so I would recommend keeping it if you download the materials. The most important thing I want to bring your attention to that we haven't talked about as much is appeal rights. So if you look in Ohio, as I said, families must be notified and informed of their appeal rights. I believe that's in that initial letter. In Michigan, there are appeals, and those are going to be conducted through local school board policy. So the rules of how that's done go from school to school. So for example, here in Michigan, I have had a case where the student went before the entire school board, which was ended up being made up of like 14 members for their disciplinary hearing. When they lost the disciplinary hearing, the appeal was actually before a subpanel of 3 school board members. So things like that, the structural elements are completely varied district by district based on school board policy. In Pennsylvania, it's the same. It's going to be an appeal to the local school board. So just keep that in mind if you are in a position where you're needing to appeal any discipline that's been imposed against your student. All right. What do we do when advocacy is not enough? What do we do when, we're going to the IEP meetings, we're going to the 504 meetings, we're documenting, we're picking our battles, we're knowing our needs, and it's not enough. What do we do when things are still going wrong? And I'm going to stick to that sort of behavioral aspect, and we'll talk about, kind of student discipline, especially if your student is engaging in problematic behaviors, especially if your student has faced discipline in the past or continuously faces discipline. We have a lot of cases where parents come to us and say, my kid will be in school for 2 days and then get suspended for a week. And then, he's back for 3 days and then suspended for a week. And it's just on and on. Never consent to the police, even the school resource officer, questioning your minor child without you present. Now, there are a few exceptions if they feel that there is a physical threat to safety. For example, if they get told that there's an active shooter threat, they can question your child and ensure that there's no weapons on them. But generally, if they are reaching out and saying, hey, we heard about a bullying incident and we want to talk to your kiddo, you have the right to be there. And do not let a district bully you into thinking that your child is too much to handle, too much of a problem, too much behaviorally, or that you are not enough. It's unfortunate, and I don't think this is all districts, but it does happen, and I have seen it in my practice where sometimes when a district messes up, they will say that the parents were the ones not doing enough. I think Jacqueline brought up a great example yesterday when she mentioned her state complaint, where it ended up that even though the school had clearly violated child find, everybody was saying that mom and dad messed up because they didn't ask for an evaluation soon enough. Don't let that poison your thinking or your perception of your student or yourself. You are enough. Your child is not too much. And I think when you keep in mind that this is a marathon and not a sprint, that there are ups and downs, there are wins and losses, you can continue moving forward and fighting for your child. My biggest piece of advice in terms of student discipline and advocacy for your student is to know when to retain an advocate or an attorney. I cannot tell y'all how much. I would say very often. I mean, I'm getting consults a lot about this, especially toward like mid-school year when kiddos get restless and we start to see sort of an uptick in behaviors. I get a lot of calls from parents who say, I didn't think it was a big deal. I went to my kid's hearing. I thought they'd give him a slap on the wrist, and now he's expelled. Can you help us? And of course, yes, I'm happy to jump in and try to help you apply for reinstatement or appeal, if you're still within the window when you can appeal. But it would have been a lot more beneficial for me to be able to advocate for this student at the outset, at that original disciplinary proceeding. And so, I would say know when you need help and reach out for help at the outset and not after the consequence has already been implemented. I think the thing that's difficult, and again, guys, I'm kind of aging myself here, but it's not really like it was when I think safe to say most of us were in school. Things have changed. And I think a big part of that, especially in Michigan where I practice, is the tragedy that occurred at Oxford. No district wants to be the next Oxford. No district wants to have another tragedy. And so districts are taking very seriously anything that they determine to be violent or a threat of violence. And as a community member, of course, I'm happy that they're doing this. As an education attorney who sees how kiddos are being impacted by this, I will say, it ends up with a lot of students who are not a real threat and who are maybe making a joke in poor taste, maybe speaking in a way that is impulsive and not appropriate, but impulsive. I start to see these students suffer very severe consequences. So just know, districts are handling things, I think, in a lot more strict approach than they used to. And so if your student is facing discipline, that's something that I do recommend that you reach out to an advocate or an attorney to at least consult about and discuss. And then again, rule number 4, my favorite rule, always keep fighting. Don't give up. Because at the end of the day, even if your child is expelled from a district, there are things that we can do to try to get them an education. There's Flex High programs. In Michigan, we call them Flex High. It's like the hybrid online, in person. I don't know candidly what they're called in Ohio and Pennsylvania, but again, if Kathy or Renee want to jump in at any point, that's fine. All this to say, your student is going to be okay. We can move forward. But best practice is let's try to avoid them getting that long-term discipline in the first place, right? How to be a sword and a shield for your student. This is the most important imagery in my practice. I like to think of myself as primarily a shield for students, and once in a while a sword. So we got to know the difference between defense, which is shielding, and offense, which is that sword. And that really is what comes down to picking your battles. For me, picking your battles really means knowing when you're going to have to be strict, or when you're going to have to, kind of be flexible, right? So for example, we talked about, I think in Corianne's presentation, again, she did a really good job of explaining that, there are times when maybe the district is wrong, but maybe we just have that reasonable conversation with them. We put it in the past and we move on. And a big part of that is because, like I said earlier, this is a long-standing relationship. And you want to maintain a good relationship if you have it. If you don't have a good relationship with your student's district, we want to try to fix that if we can. And that's kind of where the shielding comes in, right? So primarily, if your student is facing disciplinary issues, or if your student is being labeled as, I hear this one a lot, and it's one of my, it makes me so angry. It's one of my least favorite phrases in the English language, but hearing the words problem child. As you guys can imagine, I think I speak for all of us again when I say, we hear this a lot. And I think that is no way to describe a human being, let alone a child who's still growing and developing and becoming who they're going to be, right? But if your student is being labeled that way, if your student's being pigeonholed that way, that's when we come in and we have to be that shield. And I think it's a delicate balance. And at the end of the day, there is no one advocacy strategy that works for every student. There is no one advocacy strategy that works in every district. And I think that's what I want to do with this presentation, and my goal for my practice and my entire legal career is to make parents feel empowered in this process. And the reality is that means you're going to have to trust yourself. I always tell my clients, I want you to trust your gut instinct. You know your relationships with the district, you know your relationships with your student, and you know your student better than anyone else, far better than I do. And so if you know, hey, look, I've tried everything, I've tried the reasonable conversations, I've tried X, Y, and Z, and it's not working. Okay, then we stop shielding and we move to sword, and we file a state complaint, or we file a due process complaint. We take it bigger. But it's, again, about getting into that groove of knowing that for yourself when it's time to shield and when it's time to sword. And I have the second bullet here, perfect the art of convincing them it was their idea. For me, you guys can probably tell I'm a little bit shy. I am not a naturally aggressive or even confrontational person. So it's kind of funny that I went into law, but really, I think, the biggest thing is knowing what strategy feels right for you and comfortable for you. Some folks are naturally, very aggressive and able to kind of seize control of a situation. Other folks, I think, are more approachable. I like to think of myself as an approachable person. And I think when you're true to who you are at your core, when you're true to your relationship with your student, that advocacy really benefits. So what I mean by that is, when I go into a meeting, I always try to assume that it is ignorance and not malice, that someone is unaware of what the student needs or unaware of what should be done and not intentionally trying to hurt a student. And by going in and being, collegial and trying to be reasonable, I find that that often works for me. And so at the end of the day, you can kind of push for what a student needs. You end up convincing the IEP team that it was their idea. And that works for me. So that's just an example that I used here. But like I said, I want you to feel empowered in this process. And a big part of that is knowing what works for you, but also, like we discussed in this last slide, knowing when you need help. There's certainly no shame in needing help. If you need a counsel or an advocate, know when to do that and know that it's okay to go and get that assistance. And of course, we're here for you if you need us. Um, the last point I would make is maintain self-control, even when you want to scream. And I know that that is very difficult. I'm sure I'm preaching to the choir here, y'all, because everybody knows that, we don't want to look bad in these meetings. We don't want to look bad in front of the school board when we're trying to advocate for our student. We don't want to look like a crazy person, or one term I hear a lot is a helicopter parent who's just hovering at an IEP meeting. And that can be really difficult because it's incredibly difficult. Again, I'll just use that context of a discipline meeting. It's very difficult to listen to people make comments about your child or talk about your child as though they are a problem, even if it is behavior that your student did engage in. That's incredibly difficult, and it's a taxing thing to sit there and listen to that. But you have to maintain that self-control. I can't emphasize that enough. I've had several cases where, you go in front of a disciplinary hearing and, mom and dad, parent, guardian, they just want to yell at the board, and that is not going to get us anywhere. And part of advocacy is being able to put aside our own feelings on the issue so that we can appropriately address the situation for the student. That's a very difficult part of it because there are many times, I promise you guys, no matter how long I do this or how many hearings I do, there are so many times that I myself want to just stand up and say, this is ridiculous. But we have to maintain that self-control even when we want to scream. And I promise you guys, I know this is a difficult thing to hear, but I really do live it. I even have always keep fighting tattooed on my wrist. I live by that. Always keep fighting for your student, always keep fighting for your family, and know that we are here to fight for you if you need us. All right. I hope I'm not over my time, but I'm happy to take Q&A questions if there are any. And just so our other presenters know, guys, I think I'm having some tech problems because I can't actually see the chat. So if someone can read them to me if we have questions, that would help.
Yeah,
Hi,
absolutely.
Megan. It's
go ahead.
Ruth. I'll jump in here. We do have some great questions that I think are perfect, and you've touched on some of these topics. One of our participants is asking, and we touched on it yesterday about the discipline. Parents don't get called when a discipline issue has happened and the school involves a school resource officer. Interviews happen. Or participant is asking, is it illegal? And what recourse should the parents take when their student has been called into kind of this confrontational situation thereafter?
Sure. So yes, but also no. I will tell you at the outset. And the reason why is because what I briefly touched on, where if a school resource officer determines there's a threat, they can question your student. And so districts often fall back on that. What I would encourage you to do, and one thing that I've been able to get for districts in the past is I would encourage you to request that your student has a provision in their plan, whether that's IEP 504, or honestly, even if it's just something that's in their file with the district, if you're comfortable with that, a provision stating that unless it is a physical emergency, they need to have you be physically present with your student before questioning them. Now, many districts will push back on this. But as an attorney, I've been able to secure it. I don't know if anyone else has been able to, but again, feel free to weigh in. It's something that I would encourage you to do. And this goes back to my golden rule number 1, right, guys? Document, document, document. If the school resource officer talks to your student about an incident that happened 3 days ago and they don't call you, they don't let you know, document that. Send an email to the superintendent and say, hey, this is what happened. This is why I'm not comfortable with it. This is what I want in my student's file. And if it happens again, you document it again. And that's something that, again, it can be tedious, but it's really building that record for your student.
Yeah, Megan, I think that's exactly right. The only other thing I would add is that most school districts have a policy that says something along the lines of, if law enforcement is involved, we will reach out to parents and contact the parents right away. But even though they have that policy, a lot of times it's violated because the resource officer or law enforcement, if they're at the school already, will just start the questioning. There's really no limitation, if they are trying to get to a bottom of the issue for which they've been contacted, that the law enforcement can't do the questioning. So usually the district administrators even don't have the authority to stop the questioning before the parents get there if law enforcement starts it. And even though it's a technical violation of their own school policies, I mean, it's a technical violation of their own school policies, which there's no remedy. So your advice to, if you suspect that may happen or it has happened, to get it into a communication plan, at least gives it some, additional authority outside of the school policy.
Yeah, absolutely, Mark. Thank you. And I do just want to add, because I think I saw someone posted a follow-up question about where to document that. If it's on an IEP, I even will have them, put it in at the very end as like an additional provision. But putting it in a communication plan, I think also is perfectly valid. So there's, many different ways that you can do it, but ultimately, I think, Mark, you're 100% right. If law enforcement outside of the district is coming in, it's kind of a shot in the dark here. Certainly, I've never seen a district try to stop the police or have the authority to stop the police. If it's a school resource officer who's posted up at the school every day, I think that's a little different, and generally they handle it a bit differently. But certainly if you or your student have had an interaction with the SRO or with law enforcement about school, and you want to talk about it, I would really encourage you to, to consult with an attorney or an advocate and try to figure out if there's anything you can do further to try to prevent that from happening again.
Okay, Megan, a couple more questions on here. We have a great question in here about school resource officers. I just want to say, I think this is a really good one because they're asking about some differences across states. That's a great one for our last panel discussion today. So we'll hold that question till the end. We do have one person asking about timelines for those written notices on suspensions. We see it all the time. The notices come in the mail a week later. How do you deal with that? What's your recommendation to parents, to other people who might be on the call here about dealing with it and documenting it?
Sure. Yeah. So unfortunately, there's no universal time frame. I wish there was. I think generally the rule is a quote unquote a reasonable time. What a reasonable time is, who can say, right? And I have seen that before, where a student will be removed from school on a Monday, and then the following Tuesday, the parents get a letter that there's a disciplinary hearing on Thursday. The first thing I recommend that parents do is immediately respond to that letter and say, okay, I just received this notice, even though my student has been out since Tuesday of last week. Because I am just getting the notice with the allegations against my students, I do not have time to adequately prepare for the disciplinary hearing. My first recommendation, of course, is to retain counsel if you can, or an advocate, and make sure that that person is involved in the scheduling conversation so that they can attend the disciplinary hearing alongside you. But as a parent, as a guardian, I want you to feel empowered to push back and to say, no, the purpose of this notice is so that I have the information I need to prepare for my student's disciplinary hearing. Because I am just receiving it, 24 hours out from the hearing, I need more time. The school board is going to have to reschedule. And I really encourage you to make that communication in writing. Because the last thing I want is for it to be an informal conversation with the principal, and the principal says, don't worry, we've got it. And then they don't do anything that they promise you. Make that in writing, document, and then go forward from there and reschedule it at a time that works for you and for your counsel.
I'm not sure where the Q&A attorneys are going to go next, but there's a really good question here that I want to help answer, and we have a couple minutes. So for the sake of time, I'm gonna just paraphrase this. This is a situation which you can read. Once we answer the question, you can everyone should be able to read it in the answered questions. But it's in regards to, on one hand, a parent who's emotional and sometimes it says emotionally unsustainable. The relationship with the district has broken down. The district's digging their heels in terms of qualifying the student, and providing a FAPE. And the district attorney has sent the parent a cease and desist letter, which we see on occasion. One thing that the reason I wanted to jump in here, Megan, and feel free to add to this however you like, but we on the first issue. So certainly, if you have a client who's communicating with the district, which is not helping your advocacy, I'd say, if the heart-to-heart with that client doesn't work, it's time to cut it off. And that's one thing that we've worked over time to be much better at, informing parents up front that, this won't be accepted or acceptable if it continues. And that we just have to cut it off if they're harming our efforts to get services for the student. So that's number one. The second one, and the reason I wanted to chime in here, is because there are occasions where districts use this cease and desist or no trespass order to keep as kind of a sword in the way that you mentioned, Megan. And I would just encourage anyone who's in an advocacy spot to look at this Sixth Circuit case, which was decided in 2023, about 2 years ago now. And this is McElhaney versus Williams, which we can drop in the Q&A box, in which the Sixth Circuit decided that suspending this parent who is, really arguing on behalf of this coach being unreasonable, suspending the parent only for, I think, a period of 2 weeks in that case, was retaliatory. So it actually kind of established a parental right and determined that was First Amendment retaliation, which we've used in a couple cases since then. So I would just point that out. That's McElhaney, McElhaney versus Williams in the Sixth Circuit. And it's just a case that, has been helpful to us to kind of push back, because it used to be the districts could just exclude parents from school property with really no limitations, give them the C&D or the no trespass order. So that is helpful where you think it's an overstep or retaliatory based on the parents' advocacy for their own child. And that I just took up all the time, so I'm sorry about that.
Oh, no, you're fine, Mark. I mean, I would say I agree with that 100%. And I'm not sure, I'm just skimming through the question here. I'm not sure if this participant is an attorney or an advocate. I don't know if you are, what your engagement letter looks like, but one thing I would strongly advise is to make sure that you have a provision in your engagement letter, whatever that looks like, to state the terms under which you could end that relationship, whether it's advocate client or attorney client. Like Mark mentioned, we have in ours basically a statement saying that if that becomes unsustainable, if the client is making those communications outside of our advice, then that's something that we could use to sever that relationship. I do just want to say, I really empathize with that. I came to this practice from being a public defender, and so in public defense, you get assigned clients and you don't ever really withdraw. And so that was a new experience when I went into private practice, and it can be very difficult emotionally. And I want to make space for that. And I would just say, I think my best piece of advice that I could give you is that, I think in this situation, that it's time to go. And trust that gut instinct, like I had advised for parents to trust theirs. You as an advocate or an attorney should also trust yours. And truthfully, at the end of the day, nobody benefits from advocacy or from representation where the parties are misaligned and there's that emotional turmoil. So ultimately, you're not doing yourself favors or the client favors by taking it on further if it's unsustainable. And so I just would encourage you to feel empowered to withdraw if you're feeling like it's the time to do that.
Thank you, Megan. And we actually still we go until 11 a.m. for this session, so we do have a little bit of time. So if I can ask you another question, hopefully it should be a good one. I think that you'll be able to answer pretty easily, hopefully. But I know this session has been dedicated to advocacy strategies specifically for parents and guardians, but I'd like to hear about what you think about the importance that a student's role is in their own advocacy, whether it is related to discipline, maybe using their voice to advocate for themselves or in other circumstances.
Yeah, absolutely. That's a great question, Renee. I would say this. Um, I have had so many student discipline cases, so many IEP meetings, so many MET reports come through where students get involved and they advocate for what they need, or they, in the case of discipline, advocate for, the truth or their narrative. And even when we don't get what we want, even in discipline hearings where, we gave it our best shot and that student still ends up facing a long-term suspension or an expulsion. I have never had a kid tell me, I wish I hadn't spoke up, ever. In fact, even when things don't go our way, I've had kiddo come up and say to me, I feel really good because I put it all out there because I spoke up for myself. Um, and I think that's very powerful. I think it's an empowering experience for students, but I will also say, whether it's in the context of, just speaking to your IEP team and advocating for an accommodation, or even speaking up to a school board and saying, hey, I did not do what I'm being accused of, or maybe I did do something, but the circumstances were different, than the way they're being described. That's very powerful. And frankly, excuse my language, I don't really know any other way to say it, but I think it takes a lot of guts. And I know, I didn't have the capacity to do that when I was 12, 13, 14 years old, like some of these kids are. And it's really powerful even to see. And frankly, it's one of my favorite parts of my job, to get to see a student use their voice. And I think it's very powerful as well on the other end, receiving that message. I consistently have, in disciplinary proceedings, school board members come up to me and say that they're glad that they got to hear from the student. So all this to say, I'm sorry, it's a long-winded answer, but I would just say that, I really believe that a student's voice can be the most powerful one in the room, and I encourage them to use it.
Yeah, I think that's an underutilized technique, so long as the student and parent are comfortable. And I think that absolutely can be beneficial. So thank you for that. There was a question that's been answered by the assigned attorneys, but I wanted to share some thoughts on it too, because I think it's a really important one. You can see it in the chat, but it relates to what evidence the parents and student will have access to. So if they're using, Snapchat screenshots, if they're using cell phone videos from other students, if they're using videos from the school, in the hallway, in regards to discipline, those because they're going to be used to discipline the student or be used in the suspension expulsion hearing, those become education records, which the parent and student have an absolute right to receive. The answers that were provided in the Q&A are correct in that, to the extent they identify other students, that they can be redacted and still produced by the school district to the parent and student who's facing discipline. So that's one aspect. And then it comes up often, and Liz provided a good answer to this, in regards to video that's being used. First of all, it's wrong for a school to just withhold a video because it just contains images of other students. So this could be on a bus, this could be in the cafeteria, in the hallway. And the number one, the guidance from the Department of Education has long said that, if you can blur those other images, redact them, that the district should provide those videos. But beyond that, I would say, they've also provided guidance, and again, this is now long-standing. This is probably 10 years old now, but they still use FERPA as a shield as an excuse not to produce the records. In these videos, if your student or child is in the subject of the video because of, let's say, a fight or an incident in which they passed a vape, or any other incident for which they are facing discipline, it is their education record. So it gives the parents an affirmative right to view the video, not possess it. FERPA only requires that they have access to the records in terms of a video. So they have an absolute right to view the video. It is not the education record of some 10, 15 random students who happen to be walking by or even watching an incident happen, like a fight, who happen to be in it, happen to be on the bus. That is not an education record, because observations of students, just as if the bus would pass by your house and you would see it and see the students' faces on the bus, observations are not education records. So they're not protected in the way that the district would like you to know or think. So it's in fact, they don't have to blur the images in most videos, so long as there's not another subject in the fight, so or incident or event. So I just wanted to share that because it's a really good question and it comes up a lot.
Yeah, absolutely, Mark. Thank you. And I know we're hitting 11 o'clock, so I will just say I've experienced that myself. And again, empowerment is the theme of our presentation here today. If your student has a video being used against them in a disciplinary proceeding, you have the right to view it. And if the district pushes back on that, please feel free, give me a call. I'm happy to talk to you and to talk to them. And I hope this was helpful and informative. I know when I get off of these presentations, I always think like an hour later, oh my gosh, I should have mentioned that. Or if I'm watching a presentation, I always think, oh my gosh, I should have asked that. It's really no bother. I'm always happy to answer follow-up questions. If anyone does have any, please reach out to us. And thank you so much.
Thanks, Megan.
Thank you, Megan. I was gonna say there's just two more questions. They're not really questions, but just a comment that, students are tech savvy these days and can really go into, it's really helpful when students are kindly pointing out, to the technology team members when they're using something in a team meeting, and that they really say the best things. And since they're becoming adults, they need to learn how to effectively advocate for themselves when they age out of the district. So it's good to encourage them to attend their meetings. But really, thank you so much for this presentation. I know it's been helpful to a lot of people, hopefully everyone that's listening in. I believe Elizabeth has dropped another evaluation link in the chat, and I also dropped in the chat one of the cases that Mark mentioned, McElhaney v. Williams. So you guys are free to go ahead and please submit your evaluation. We value your feedback. Otherwise, we will be going on our break until 11:10 a.m. and we will see you then.